Upward just a little bit. That's it. Good. Okay. Hello, my name is Leon, and this is my first attempt to do a YouTube. I will tell you in this video how a deposition works, presuming that you were, for the purpose of this deposition. We're going to start over now. This is part 2. Hello, my name is Leon. This is my first attempt at a YouTube, and I'm going to try to tell you about what happens when they take your deposition. Although I practiced law in the state of Ohio for more than 45 years, I am now disqualified as an attorney. I'm no longer a member of the bar, but I did have about 1,000 depositions behind me while I was practicing law. I am now not giving you legal advice. I suggest you get representation from your attorney, but this may give you some idea from the experience that I have had, what you might ask the lawyer and things to think about. Now, consider what I say no more important than what you would hear from a bartender, barber, or a friend, because I am not licensed to tell you these things. These are my disclaimers. I'm just going to tell you about my experiences as a lawyer for so many years, and I am hoping that this will give you some insight as to what's coming up. Well, the second part of your case that's most important is the deposition. The rules of civil procedure permit each party to ask questions and find out any information they want and look at records almost without restrictions. This is called discovery. Discovery is a section of the civil rules that permit the lawyers to trade information and find out from each other what they're going to be saying at a trial. Now, a deposition is just one part of it. There's also interrogatories, those are written statements, and there's discovery of documents. We're only talking today about your deposition. And from the purpose of a personal injury case, I'm talking from the standpoint of the plaintiff, the person who was hurt in the accident, and is trying to get money from an insurance company from the defendant driver. Most cases are settled and they don't reach the part of a deposition. But if the lawyers cannot agree on a way to settle the case, you go the next step, which is to prepare for trial. Some lawyers think your deposition is even more important than the trial, since 80% of the depositions settle, the cases settle after the deposition rather than go to trial. The deposition is very telling to all parties as to what is going to come up in the trial, and therefore sometimes the trial is really not necessary. Now, a deposition that you'll be experiencing takes a long time, often 4 hours or more. That's what I found to be about the average. You should plan on taking the whole day. Don't park in a place that you're going to have to go out and use a meter. And be prepared for a long, drawn-out process. A deposition, because it's one of the methods of a trial, is under oath. It's transcribed by a court reporter. Sometimes it's done by a court reporter plus a video image that can be played to the jury at a later time. That is more popular than ever now. It's not your time to tell your story. It's not an opportunity for you to debate the issues. You are not in control. The person in control is the person who is representing the insurance company and will be asking you the questions. In fact, the questions will not seem to you at the time to be often relevant to what happened. You'll have your chance to explain your position and what happened as the preparation of the trial continues. Now, if there's something in your history, a criminal record, an unfortunate other accident that caused you a problem, be sure to confidentially tell your attorney about it so you don't have the opposing counsel hear about it for the first time and your attorney hears about it for the first time. You can't take your attorney by surprise. Now, while defense attorneys often appear very friendly and helpful and caring about your case, believe me, they are not interested in your welfare. They are hired by the defendant's insurance company to get information from you that hopefully will damage your case. They want to try to blame the case, first of all, the accident, on you. Then they may suggest that your injury was not at all from this accident. It was from former problems that you had, or health problems, or other accidents. They also want to say, if you were injured, that it wasn't a serious injury, and you didn't need all that treatment, and you don't have to come to the insurance company for money because you didn't need that treatment. So your lawyer will want to show that your treatment for your injuries was reasonable and necessary. Those are the two magic words that support your medical condition. Because the medical condition and how you were treated is a primary element in determining what the case is worth. Well, this is the lawyer's job. Your lawyer wants to allow you to give the deposition in the best way you can, with as much truth as you can, and it is the lawyer's job for the insurance company not to allow you to look good. He is purposely trying to destroy your case. He is not purposely trying to be a bad guy. He's a straight-up guy. He's just doing his job. You have to follow your lawyer's advice and do what he says for the purpose of the deposition. If the attorney for the other side does appear to be extra friendly, he may be probing you to talk. And he wants to see what kind of person you are. Would you make a good appearance before a jury? So keep that in mind. That's his motive. Now here's some things that will help your case the most. Understanding what is the purpose of the questions you'll be asked. It's really in three parts. There's three sections to the questions if the lawyer follows the standard. First, he usually wants to know about your whole life, including your health, your education, whether you have a criminal record, relationships that you've had, your former addresses, your employers. All of this doesn't seem important to you, but sometimes when they have some questions about your character or history, they'll use this information to find out more. Don't say something like, well, what's that got to do with it? We've had clients that said that. What are you asking me that for? That doesn't have anything to do with this accident. Well, let me tell you, they can ask you anything they want. If there is something that's out of line, totally irresponsible question, your lawyer will object, and I'm going to cover objections in just a minute. Well, okay, so just answer all the questions, and in the event that the lawyer says objection, you'll know what to do after I talk to you about this. The second portion of the deposition deals with all the facts that relate to the incident that occurred about which you are making a claim. Now, this could be the way the accident happened, it could be anything that happened before or immediately after. This is what they're trying to find out you know about it. He will test the limits of your understanding and knowledge of what the case is about. You may expect a number of questions that you won't know the answer to, but that's okay. Just keep going, and if you don't know the answer, you're going to say so. A common problem in the taking of a deposition is a client's ability to remember the time and distance factors. So many times they are asked, well, how long did you stand at that red light? How long were you there? Most people say something like, just a few minutes. Let me tell you, there's not many traffic lights that last a few minutes. Consider a question regarding time to be answered with accuracy, usually seconds. Look at your watch, if you have to determine what seconds it took, rather than to guess or just say, oh, just a few minutes. And what about distance? So many people say, well, I was just a few blocks away. Blocks can be pretty long. So don't exaggerate. Don't say, oh, there were a ton of people that saw this, or there were hundreds of witnesses, or anything like that. That is not an accurate statement. And if you're not giving an accurate statement, essentially, you are either guessing or lying. And your lawyer does not want you to appear to be a liar, nor does the jury want to believe everything you say if you appear in just a few questions not to be telling the truth. Now, the third aspect, which is sometimes called the money part, presuming you're the plaintiff in a personal injury case, you are going to be asked things like, what is your loss? What did it cost you? In a case like a personal injury case, they're going to want to know if you had medical expenses, how much they were, did you lose wages? And here's the real question, what can't you do now that you used to be able to do just fine? Pick up babies, go to the store, do your athletic things with friends, or play ball, or jog. All of these things are important, and it's worth taking some time before your deposition to go over, at least in your mind, if not on a paper to remember, what things you can't do anymore. Think about your answer. This is the important part that gets the sympathy of the jury. Everybody's in accidents, everybody has problems, but how does it affect you? Now, you're permitted to take breaks during the deposition. Lots of questions, lots of answers, and it's uncomfortable. You may want to say, can I take a break? So if it's not in the middle of a question, you just say, may I take a break? And there's never going to be an opposition to that. Another thing about a deposition is if you want to stop and think about the question, you can take as long as you want. Unless it's videotaped, it does not appear in the record, in the written record, how long you're taking to think about it. So you're going to want to take your time and answer truthfully and correctly. That's the way it has to work. As I said, it can't be in the middle of a question. It looks very, although I don't know of any rule about it, for you to stop in the middle of a question and before you answer say, can I talk to my lawyer? I've had people do that and nobody seemed to bother, but it looks bad. It looks like you're being prompted. So don't even try something like that. Now, if a lawyer says objection during the process, usually after a question, objection, sometimes the lawyer will preface that or say